rise. For the district, the floor is now in session. Jacqueline Margaret, and Judge. First, this is for the sport drawing. Here, give attention and you shall be heard. The God of the United States of America. Florida. Please be seated.
Good morning, everyone, and welcome to a morning session of oral argument in the 5th District Court of Appeal. We have 3 cases to be heard this morning. They're all civil cases, so each party will have 20 minutes to the side to argue. Don't feel that you have to use it, just know that you have it. Let me introduce the panel. As you've already heard, I'm Judge Griffin. To my right is Judge Cohen. And to my left, I'm pleased to say, we have as a visiting judge from the 7th Judicial Circuit, Judge Wendy Berger. So, without any change in the docket or any further ado, we'll call the first case, SHETH v. SHETH, and the appellant can begin when she's ready. And since you are pro se, since you're both pro se, I don't know if you've had the opportunity to see some oral arguments that have appeared on our website. Hopefully you have.
I've been part of one, Your Honor.
But let me just let you know that you do have 20 minutes. There is a clock on the podium, and you can keep your time that way. If you want to reserve some time for rebuttal, then you as the appellant need to let me know that right now, and I will try and at least give you a heads up when the time that you've asked for has arrived. Once your time has expired, then the argument will cease. Do you have any questions before we begin about the procedure?
No, Your Honor.
Okay.
If you can remind
All
me,
right.
then it's like
I'll
about
ask
5
you to
minutes.
speak up.
5 minutes for rebuttal, please.
Very big room.
Okay, 5 minutes for rebuttal, Your Honor.
Perfect.
Good morning, Your Honors. I'm PURNIMA SHETH. The appellant in this case was the SHETH. I'm before this court because my due process rights have been violated. I have the opposing counsel has breached court protocol and has run over my rights. As Judge Lawson writes in his case of Department of Transportation versus Christopher Bate.
Could I ask you just to slow up a little bit?
I'm sorry. The basic requirements of procedural due process are notice and an opportunity.
Speak up.
A notice and an opportunity to be heard. As Judge Cohen has stressed in the case of Masibo versus Masibo and in the case of Kathy Moore, the importance of procedural due rights. Court orders have been changed and entered without pleading and without testimony from time the trial judge was assigned to the case, which was November 2006. This is not about the other judges, it's only the trial judge. The order on all pending motions lacks corresponding pleading and was the deciding factor for the entire case, how the assets were to be divided. Everything was decided by this case and, without giving notice, and I wasn't heard. The opposing counsel, took the grandstand in that case. The judge has acknowledged, as in the trial transcript of August 24, 2007, page 100, that he signed this order, which is supposed to be a stipulated order that the parties have stipulated, without my agreeing to the stipulations, and it's there in the transcript. Therefore, the order needs to be set aside. The fact finder has also stated at the
rehearing. There was a motion that was filed that addressed that issue, did it not?
There was a motion that was filed, there was an appeal that was filed, and there was a motion to disqualify judge, which was denied. After that, the appeal was filed. It had to be withdrawn because the order on all pending motions was a non-final order. And
what do you contend most prominently is the error in the order?
There are like 15 pages that I have written down in my brief. I wouldn't be able to go one by one.
Well, give me an example of what you think is the most glaring error in the order. What's the biggest problem with it?
Okay, objections to the order, it's on my brief on page 11, and I'm not prepared for this. Okay.
It's all right. But you've made this your first point on appeal. You've said we have to set aside the order. The order itself is erroneous, which would mean that we would have to go back and retry the case. And it would have to be based on the fact that there was a failure of due process in issuing that order. The trial court has heard you on this point and has refused you relief. Is that not right?
The trial court did not provide me a hearing, refused the hearing to the objections.
But he entered an order, did he not?
He entered the order, and it's on the in the transcript that he ordered without my consent.
Well,
and the order
he heard
itself,
your complaint that you did not get an opportunity to correct the order. He heard that.
No, he didn't hear that. There was no hearing set for that.
Well, you filed a motion and the judge ruled upon it.
No, the judge did not rule on it. The judge said that have fun at the appeal court. No more hearings. That's what we were told.
But he entered an order denying it, did he
No,
not?
there's no order denying it.
I'll look.
We were not given the opportunity. There were several pending motions before the trial, and he just told us, no more hearings, have fun at the appeal court.
Is it your position that everything in that order was erroneous?
Is your position?
Is it your position that everything in that order was erroneous?
Not everything.
Okay, so I think that Judge Griffin has asked you to try to narrow it down for us. What do you think was erroneous in that order, and prioritize it in terms of the importance of
May I
those
just
issues?
refer on this, Your Honor? The list of assets that was given was only the list that the appellee gave to the accountant, and I had placed objections on that. And my list had $50,000 Colonial Bank CD, which was on it and which was not given to the accountant. Then independent assessment of the accounts wasn't done. Husband showed a drastic change in income from $500,000 to $42,000 a year, and this wasn't addressed because the judge said that he wasn't going to use the new accountant. He entered an order saying that petitioner's motion to refer certain to the general master is denied. I didn't even file a motion like that. There is nothing in the progress docket showing that I filed a motion. Then he said that petitioners, there were several things that he ruled on, 3 things, which without even having a pleading on that. I didn't file any motion, and he had his orders written out.
Okay. Well, let's go to the issues that are in the final judgment that you contend are erroneous.
Right.
Let's work on those.
The first issue is the Oracle business cap account, and ending in 0137. The court has ruled based on the testimony of an accountant who has not seen the fundamental document of a tax return and has given testimony that would affect the distribution of an account with a value of $245,000. It could be considered a statutory violation in the practice of accounting. You
had your own accountant testify as well, correct?
Yes, but the judge ruled on what he had. The judge did not...
The judge listened to your accountant as well, correct? And then made a decision as to which of those 2 accountants' testimony was more credible, correct?
Okay, Your Honor, first I think
If I could just get you to answer that question for me.
Right.
You had your own accountant that testified, correct?
Right.
And the judge listened to both accountants.
Listen to both the accountants,
Yes.
right?
And chose to go with one accountant rather than the other accountant, correct?
That's right.
All right, and you're complaining about that.
I'm not complaining, I'm showing you the facts. that there is a tax return that shows that there's a $135,000 distribution, and my accountant and the court-appointed accountant both have said that there is a distribution of $135,000, and he has taken an accountant that was appointed on the day before the trial without notifying us. The notice was like at 7 o'clock, the day before. And he has testified that he has not seen the tax return. My question is, if you haven't seen the tax return, then why are you saying that, $135,000 is not the distribution from the last year? Go ahead and look at the tax return and then come and testify.
Well, the trial court actually ruled on the basis that the expert's testimony was contrary to the instructions that the court had given, didn't he?
Well, then the court made he was appointed based on against my objection. I had asked for an independent forensic accountant. The husband changed the court orders and got an independent forensic accountant, removed the word independent, got, accountant of respondents choosing, got his own personal accountant, and then they came up and they are saying this value of $245,000 is $45,000, something like that. And so I forgot the question.
The question was, the trial court, as I read the order, the trial court said, I don't care what the expert says. I told him to do
certain
income,
things.
expenses,
Okay.
and he didn't do that. He came up with these other two categories, and I'm not listening to those other two categories.
So my answer to that is that you made the mistake of appointing against my objection. The court made the mistake. It was against, I told right from the beginning, he's not a forensic accountant, he's not listening to me, I didn't even get to give my assets on the list, only his assets that he gave. That means we have several thousands of assets outside which are not even there on the list.
Let me just tell you what I'm having trouble understanding. Is it your position that the accountant, what was his name? Mr. Segar. Mm-hmm. Is it your position that his testimony was wrong?
It's not my position that it is wrong, but the way he handled he was not a court experienced accountant, so he was not doing the procedure the way he was supposed to, contacting both the parties, taking these objections and doing things the right way so that the trial court would not have any objections to it.
Well, none of that will matter if his testimony at trial was correct. Was his testimony correct?
His testimony at trial was correct, but the trial court had objection because he did not meet.
Because the trial court said, you didn't do what I told you to do.
Yes.
So you actually agree with Mr. Segar's testimony?
Yes. In spite of though I had objections, his testimony was correct.
Okay. All right. And your position is that the trial court was wrong in refusing to listen to it?
And the trial court is wrong in violating my due process rights. The trial court is wrong in saying that he did not know the facts of the case. There are 6-7 judges in this case from Judge Alan Dickey. In 10 minutes, Judge Dickey could tell that, he was lying. But this judge is saying that he's okay, that everything is fine. And he hasn't even reviewed any of the things. And he's admitting that he hasn't reviewed any of the things. I have a fact finder who's actually saying that he doesn't know the facts of the case.
All right. Is there any other issue, any other error in the court's order that you want to bring to our attention? Because you're down to 8 minutes. Is there something else that you want to talk to us about?
Your Honor, due to the time, I would just say that you have any issues with me, and I'll answer them.
Okay. Well, the panel doesn't have any questions right now, so if you want, you can reserve that 8 minutes
for rebuttal.
And for rebuttal.
I can go over for like 3 minutes and just touch base with the issues a little more. The other error in that there's all evidence towards, like, there are 3 IRB checks that were made. What I'm saying is, since there's deviation from law in the way everything was done, that the trial, I have the right now to go and have another accountant review the account. I'm not saying go for a new trial, just have another accountant review the trial, give the benefit of the doubt.
Other than the cap account, what do you think was the trial court's next biggest mistake?
Okay, the child support issue. He gave credit for unpaid court order child support. There was $77,000, 234 based on his testimony, and he was supposed to pay $88,500. And now he says that he paid it. But in the transcript, if you go to see in the trial transcript, his attorney has said it was $77,000. And then the next issue is
But
income?
didn't your lawyer agree that all of the child support had been paid?
no. We
In the
said
earlier contempt hearings?
no. In the rehearing, if you see in the rehearing, in the contempt hearing, what happened was that the judge postponed the sentencing because there was like arrearages of like $12,000. So, because he brought the payments to a certain level, then, all we had to do, and he was saying that it wasn't that any arrearages. So the judge said that you go ahead and, have an accountant find out if there's arrearages, and then, come back and at trial with it. So, in all, it should have been like $88,500, and it turned out it was $77,000 that he had paid. Then the income was the other issue with the child support. I'm not disputing. I don't care about the small amount of change that will make in the thing, but he is coming back after my assets now and asking me asking me to pay for attorney fees. This is a situation, if you look at the 1996 court order, which is Exhibit Y, a situation where the husband has taken all the assets, including my car. For 3 weeks, I was driving, a rental car. He has taken the business into the business completely and has flourished with all the marital assets over the several years while I was working in another office, making a business of my own, making a family, a house of my own, and raising 2 children without any help from anybody. Running around, doing so many things and settling without child support, and then having the burden to prove all these things in the court, which is always so difficult, Your Honor. The third issue was the retirement account, which was like divided twice to benefit the appellee. Each account has been given a value to benefit the appellee, and if you go issue by issue, I have addressed everything in there.
Okay, we have gone through this pretty thoroughly, so we have a fair idea of what the issues are. You've got 5 minutes left.
Okay.
Let me ask you to reserve that for rebuttal, and we'll hear from appellee.
Thank you, Your Honors, and please pardon me for being a little nervous. This is my first time here.
That's all right. It's understandable. Even for lawyers, it's sometimes a little bit nerve-wracking.
Thank you. Your Honor seem to be well versed in the file, so I shall not bother you with more detail. But to summarize quickly, the parties were married in January.
We don't really need all that information.
Okay.
We are pretty familiar with the facts. We've studied this case as thoroughly as we can. Let's go to the very first issue, which is the cap account, and hear from you on the question of how that account should have been treated.
Yes, Your Honor. Thank you again. Appellant has tried to explain to Your Honors a cap account, and I believe there are 2 cap accounts, one for the business and one for the personal. On the business cap account, Your Honor, the business has 2 components to its practice, a dental practice and a research practice. As you may be aware, dental practice is a cash-based business, income in, income out. A research-based practice, however, is somewhat like building a home. I'm a researcher. A corporation provides me a large sum of money to conduct a clinical trial. They pay me in advance. As the research progresses after dispersed funds, I happen to be conducting 3 consecutive trials, or concurrent trials, during the time of this filing, and therefore had a large sum of funds being awarded by these companies. Appellant claims that all of those funds, unearned, represented marital income on the day of filing. That has been the crux. Most of these arguments are based on that contention by the appellant that all of that income represents earned income. The judges declined that argument. He has allowed appellant to recruit an accountant for over 2 years, which she failed to do. She was offered 3 different accountants. Over 2 years, she refused to appoint anybody. She refused to provide discovery documents for the court to be able to analyze it. Eventually, in 2006, judge allowed my retired CPA, who appeared to be the most conversant with my accounting information, to be the court's independent accountant. He then very meticulously analyzed this account, the cap account, and was able to define exactly what represented earned income and what was unearned. So the argument that the appellant makes that the whole amount of $240,000 some dollars represented marital income is incorrect. The accountant has since defined the amount that was earned up to the date of filing, as reflected in the Exhibit A, is $30,900 and change for my research practice and $18,000 and change for the dental practice, Your Honor, if I answered your question.
Well, as I understand it, and correct me if I'm wrong, the dispute was over whether, or at least one of the disputes was over whether the $135,000 figure was actually money that was taken as a distribution to you.
Your Honor, let me clarify that for you, please. The $135,000 in question has first been contended as to actually when the funds were drawn. The check was written on May 11th, 1998.
Or May the 1st.
Or, as the appellant claims, May the 1st, and cashed several days later. That amount, in a nutshell, Your Honor, represents an advance to myself based on the potential income I expected to earn that year that I had to withdraw in anticipation of a quick settlement of this divorce case. So the essence of that fund is that I withdrew that as a salary because that was the only large sum.
A quick settlement of this case. This case has been going on for a decade. You know, a quick settlement?
Your Honor, at that time, remember it was 1998, and we had filed the case in 96. We had both agreed to withdraw. The matter had simply stagnated for a year, and then all of a sudden in 98, when appellant filed again, that for me was the first time an actual divorce case was filed, according to my understanding. And so my attorney had advised a quick settlement. He asked if I had means to some substantial funds to settle quickly. I said I would draw against my potential income from my office, which I'd expected to earn by the end of the year.
So without any type of agreement, you decided you would withdraw a sum of money, and that's your explanation for that?
Your Honor, there was not an agreement. We had expected to settle the case, mediate and settle the amount, which I, based on the understanding of what my net asset was, had expected to be in that amount. So yes, Your Honor, I had anticipated an early settlement. I kept that funds as a reserve, hoping for that early settlement, and then, as you know, it went on for 10 years. So the point of the honest question is where did the funds come from? Those funds, being that the practice is an S corporation, and therefore eventually the funds do translate to my bottom line at the end of the year, I made a business decision to take an advance salary of $135,000 on May 11th and cashed it about a week later, Your Honor.
Now, the other explanation is that it's actually a distribution for 1997.
Your Honor, that would have been drawn then in 1997. As you will see from the accounts for December 1997, there was not such an amount sitting in the bank at that time. So how could one draw that distribution? Moreover, the amount...
Well, if it were in fact a distribution from 1997, if the trial court had made that finding, and to be honest, from what I've seen of the evidence seems to suggest that that was what was done. But if the trial court were to make the finding that it was a 1997 distribution, then that would be a marital asset, would it not?
Your Honor, if it had been to your point, if it had been a marital asset and had physically transferred from the business account to the personal account, the net effect would still have been the same because both assets were still being considered in the overall asset distribution. So had they even made that transfer, it would have depleted the business account by a proportionate amount and shown up in my personal account, still causing the same net result, zero-sum gain, ma'am.
Well, if it hadn't actually been transferred, if it had stayed in the business account and not been in your personal account. then it wouldn't get picked up with.
But no, it would, Your Honor, because it would have reflected on my 1997 tax report. It would have been considered as earned income on that report, because I can only pull that amount if I've earned it. Therefore, I would not have been able to...
How do we know that you didn't take it in 1997?
It would be reflected in my personal account in that case, ma'am.
And do we know that it's not reflected?
No, I have not drawn that fund. The check was not transacted until May 15th of 1998. Your Honor, did that address your first question?
Yes.
Okay. May I continue?
Sure.
Your Honor, appellant has argued vociferously about the qualifications of the accountant. She was given 2 years plus by the court to elect one. She refused to. There were several accountants presented. As I summarized, the judge finally decided that the best qualified person was the retired accountant, and he, in fact, did a masterful job of dissecting my cash flow, and incidentally, it was only my accounts that were dissected.
The decision on the order, wasn't the decision as to who the accountant would be left up to you and your lawyer?
No, Your Honor. Judge was given 3 names, or excuse me, pardon me. I was asked to provide 3 names to the court from which the appellant would select. She refused all 3 names. She proposed a 4th one. We agreed to that. Judge agreed to that. Another year passed. Nothing happened. We approached the court for an expedited conclusion to this case. Judge wanted an accountant. We offered the previous accountant that used to manage my books. The accountant agreed to be the independent accountant. Court acknowledged him. He was given all of the documents of discovery from my side, but not from the appellant's side. It was by mutual consent, Your Honor, that the accountant was elected. And he was provided all of the information. He chose not to reference some of the information that we had provided, and that led to some of the confusion. He was also, unfortunately, threatened by the appellant and her accountant, which I suspect might have created some of the last-minute confusion. But in a nutshell, the math involved in arriving at the earned income, I think, was very well done. We all agree that there was no better way to assess that information. The only failing in that regard was that the accountant, I believe, was arm-twisted into requiring him to reflect these $135,000 as an asset, which in fact was nothing but a virtual asset because it was not a transacted cash amount, as I've already discussed, and the fact that part of his mathematics required him to look at certain documents that he failed to acknowledge, and the court therefore chastised him later. But besides that, there was no other conflict in the manner that the accountant did his work.
Let me ask you about the calculation of the retirement assets. And,
yes, ma'am.
Although the appellant didn't address this issue, the trial court said in paragraph 35, in consideration of the tax-deferred equalizing a payment of retirement assets being $66,000 and some change, husband shall transfer $36,000 as an equalizer to the retirement account of wife. This transfer contemplates the amount owed to wife and, without any tax consequences. I'm unclear as to what actually happened with that money and why the 36 shouldn't have been 66.
I understand, Your Honor. I'll be happy to address that. The math is correct and clear. Of the net assets of the two parties, which approximately 132 by division came to about 66, the appellant had asked the court that the funds be provided to her in what is considered present-day value. Therefore, the retirement asset, which is a tax-deferred amount, was adjusted for present cash value, which therefore requires the application of IRS tax and the appropriate tax deduction that impacts on any premature withdrawal of retirement assets, Your Honor. Therefore, the 33,000 and change now becomes cash asset that has been tax treated for the appellant to be able to use immediately without any further future tax consequence, Your Honor. That is the translation. The math is explained in the ruling as well.
And what happened to that money then? So what you're saying then is that the 36,472 represents a cash out for lack of a better
Yes, Your
phrase,
Honor, that's the way.
version of the $66,000 in deferred compensation.
Correct.
And has any of that money been paid?
Your Honor, the money has been defined, the money has been withdrawn, but not been transferred yet, awaiting this appeal.
No transfer of anything has happened pending this appeal?
Correct, Your Honor.
Okay.
Pardon me, other than the $50,000 that I was required to transfer early in the trial process, and for which the tax treatment that has then been applied to a subsequent asset for the appellant has not been equally applied to those withdrawals, which is part of my cross appeal, Your Honor. In a nutshell, if I may perhaps reflect quickly on that.
Sure.
Okay. Quickly again, just to summarize, we have discussed the accountant's qualifications. You have addressed the issues regarding the pending motion that the appellant had objected to. We have discussed since the $135,000 that were part of my income. The appellant had also argued for interest to be borne on some of these assets. The court has denied that because we had entered by stipulation that no such treatment shall be forthcoming. The only other appellant argument was a CD that she claimed was in her possession, and yet she's never been able to produce one. There was a previous asset that had been liquidated, and that amount of $26,000 had been set aside by the court to be finally adjudicated at the time of final judgment, which the court did eventually take into account. There were a couple of small errors that entered into the judgment.
We're talking about the Crown Bank CD?
Yes, Your Honor.
Why would that be a marital asset?
Your Honor, simply because the amounts were withdrawn after the filing of the divorce case. Funds have never
First divorce case.
Correct, Your Honor. Funds have never been commingled. We have never cohabitated since.
But that first divorce case was dismissed, legally, correct?
Your Honor, it was withdrawn by both parties several months after it was filed. But again,
Well, there's no dispute that at the date of the filing of this divorce case, that $26,000 no longer existed, right? It had been
they had been already transferred to the appellant.
back in '96.
Yes, Your Honor.
So I'm having trouble understanding why it would be a marital asset in '98.
Your Honor, because A, the parties never reconciled, the funds never commingled, the parties never cohabitated. Judge Dickey had assigned that amount because basically that had been the bulk of the family's saving at the time that was forcibly taken by the appellant and never accounted for. Assets that were acquired from that purchase were never accounted for, other than the automobile that was purchased, and that was also proportionately discounted to current day value. I don't know if I answered your question adequately.
Right. And so if we were to reverse on this point, we'd have to go back and value the car.
Well, in my opinion, Your Honor, we would have to go back and use that date then as our date of marital division. And that would basically make moot this whole exercise we have made of defining the point of measurement as May 1998 and not May 1996.
So there can be different dates of valuations for different assets. You don't have to value every asset as of a specific date.
And that's, I believe, the way it has been treated, Your Honor, that it was the bulk of the assets were defined for 98. Per court order, the asset from 96 was brought forward and treated based on inflation and all other adjustments that amount required. Basically, all of the $26,000 was not applied in full. It was depleted to present day value for 1998, Your Honor. If that helped you answer. Just to quickly summarize, Your Honor, I'm running out of time. I have cross-appeal arguments which are basically the following, Your Honor. There was only one asset in all of this disposition that was unfairly and inequitably treated, in that a very large valued asset, a parcel lot, which was valued by the appellant's appraiser at $290,000, was then allowed a capital gain tax treatment and allowed a deduction of almost $32,927, which treatment was never applied to any of the other assets that I was asked to liquidate prior to that point. I believe that to be a reversible error that should have not been allowed, that the full value of the asset should have applied, much like it was applied for the pre-distribution that I had to make, and then any other expenses that accrued over that, and those have all been reflected in the court's judgment. The only error made was that a capital gains treatment was allowed for this one asset without a basis. The other argument I have, Your Honor, is that there are two assets that I believe to be marital. One is the wife's dental practice, and the other an investment home that she purchased as an unmarried woman. These two assets were purchased from funds that were provided to her by myself prior to the conclusion of this trial, and the fact that the ability of the appellant to practice dentistry per se was in part facilitated by my being able to argue her case, having her failed the board for a board exam 3 times. I had to take her case on appeal and fight the board and eventually get her the license that allowed her the ability to practice, which I believe therefore entitles the practice as a marital asset. And similarly, the investment home, and only the down payment portion of that investment home be considered as a marital asset. Your Honor, finally there was I believe, an abuse of discretion by the court in that I was subjected to a pretty severe criminal contempt charges based on my admitted failure to pay child support for a limited period of time as a leverage to try and require the appellant to produce discovery that she had refused to provide it for almost 3 years. Judge McIntosh then chose to impanel a criminal contempt case against me, which upon new counsel I was asked to quickly make good the child support payments, and have since then remained current. But I believe that that charge should never have been applied, and I ask your court's consideration of reversing or expunging the charge altogether.
I forgot to ask you about this discrepancy between the $88,000 in arrearage and the $77,000.
Let me address that, Your Honor. The full amount of $88,500 has been paid in full at the rate of $1,475 per month up to the age of emancipation of the youngest child. The unfortunate problem in this case, Your Honor, was that the appellant insisted that all funds be paid to her directly and not through a court record. And unfortunately, at this point, she seems not to be able to have kept good records of all of the payments made. Even the court acknowledged that, yes, this was something that should have been done. Her own counsel, at the time of indirect contempt proceedings, has also recognized that, yes, all payments had been made to date. And from that date forward, the few months that I withheld child support were correctly paid from that point forward. And there is no contention, Your Honor, that there has been a single month missing after that. There is the issue, though, that at the time of trial, we had to go back and recompute all child support because over the 10-year period, the appellant had refused to provide any tax documents. We could not do this on an ongoing basis, and so all of that adjustment had to happen at the last moment. That is not an arrearage. That is simply a retroactive adjustment, and that could have been avoided had the appellant been able to provide us documents of financial information each year as required. But the child support has been paid in full. In fact, there was also child support paid during the first filing, which has not been credited to my account, and the court has not addressed that issue.
Okay.
The last two small points.
You've exhausted your time. Thank you.
Thank you, Your Honor.
Your Honor, I'd asked for a qualified domestic relation order, and, everything that he says, the appellant said this and said that, don't take it for the word. Unless you see it on the record, that's the only thing that you take, because what he says and what he does
Well, what I'm
is
just
different.
trying to understand is what the trial court's judgment actually calls for. What Appellee suggests is that the $36,000 number is a number that would be clear of any
I understand.
tax burden.
I understand, Your Honor.
And so, tell me what you think the trial judge's order means. Does it mean you get $66,000
As a
in a
qualified-
quadro, or does it mean you get $36,000 after tax?
No, $66,000 with a qualified domestic relation order, so that it doesn't, I don't have to pay the penalty now.
Well, has anything been done to see whether that can be accomplished? Because the trial court's order seems to be somewhat...
He's done all the judgment after the trial, and there's nothing in the trial document to support what he has ruled on. So we basically have to go back and correct all the errors afterwards. There is no
I'm not sure I
pleading.
understand what you mean by that.
There is no pleading to say that, I'm going to want the cash right now, or, either way. What he did was, after the trial was over, he went and, made a decision that the wife is going to want it this way, so let's just, divide it into
If it
this
can
way.
be done, do it. If it can't be done, give her $36,000. Is that right? Is that what
It's,
the effect of the order is? Give her 66 if it can be done by a
It doesn't say
quadro.
on the order that give us 66, if I'm not mistaken. It says just give the 33.
Okay. So
So-
your position is the trial court has said, give her 36, clear of any tax
Right.
liability.
That's my understanding, Your Honor.
Well, it says, counsel for wife and husband shall cooperate to accomplish such transfer through a quadro if necessary. Should there be an absence of a vehicle by which this transfer can be accomplished, then husband may withdraw the sum less the reduction of 10% and 35% with reduction for the taxes associated with withdrawal. I thought that meant that it would be 66 if possible, and if not, that the 35 and 10% would be the equivalent of 36. Am I wrong about what that means?
My understanding is that he's divided in twice, but whatever, if I could get the 66 with the qualified domestic order as the order stands, that's great.
Okay. All right. Well, that's what it appears to me the trial court has said. If I'm wrong, then y'all just need to get that clarified.
Now, as far as most of the errors, Your Honor, like you were saying about, having a new trial, I don't want a new trial, because there has been speed bumps at every level. And, when he tells you that this, she didn't hire an accountant, there's a story behind it, what happened, and there's no time for me to go over the stories. There's speed bumps at every level. I cannot move the case forward. As you can see in the appeal court right now, he's filed 18 more pages of something that was not supposed to be there, so that I would file a motion complaining that, and my hearing would go further. You see? So those are the speed bumps that have been all over. I need my assets to pay for my college tuition for my children and to raise them. I have done them. They were 12 and 13 years old, and I have got nothing. Whatever has come has been, more gone in legal fees than, getting anything. And now, if you look at his exhibit, he wants everything from my assets. And he's talking about my home, unmarried woman and all. That is, the asset did not exist. If his attorney thought that there was something wrong in that, he would have raised it at trial. It was an investment property meant to be, purchased and resell it fast, and that was the reason why it was purchased. And when he went to the bank and asked them what it is, they told him that investment property papers are prepared where it doesn't really matter whether he's married or unmarried. So, and now he comes and he claims that, this asset. And it's the same way with my practice.
You've exhausted your time as well.
Okay, thank
and
you,
let me commend both of you for pro se litigants. You've done a very fine job, and you've helped us out. So
thank you, Your Honor.
We appreciate your participation. We'll do the best we can with the case, and we'll call the next one, which is Brennan